I'm with the American Tort Reform Association. We're a national organization dedicated to promoting legal reform of the civil justice system, litigation involving private litigants.
What are we doing here today?
Well, today we're here to talk about a particular issue of interest to ATRA, which is state consumer protection statutes. These laws are well intended and appropriate when regulators and government officials use them to protect the interests of consumers, but they're becoming a vehicle for a lot of very prominent lawyers representing individuals and collecting very large fees. Sometimes we're seeing verdicts in excess of $100 million in this area around the country. And we believe that these laws, when properly utilized, protect consumers, but we think that there is a significant amount of abuse around the country, and we're here to talk about that today.
Louisiana consumers, like consumers around the country, can actually be harmed worse than they're helped by these laws because of attorneys taking advantage of the laws and trying to make a payday from the awards of attorney's fees.
Examples of some of the cases recently to show you how they can be abused is the Subway restaurant chain was sued because somebody claimed that the foot-long Subway that they received was in fact 11 inches long. And they're looking to collect hundreds of thousands, sometimes even millions of dollars in these cases. A number of years ago, in my hometown of Washington, D.C., a local dry cleaner was sued over a missing pair of pants, and the lawsuit sought over $50 million. That's the way these laws work, because the argument is that every time somebody sees an advertisement or a marketing claim, that constitutes a fraudulent activity. It adds up very quickly. Who ultimately benefits and who ultimately would get achieve the real windfall, however, is not some individual, not some plaintiff, but the lawyers who bring these cases.
First of all, thank you very much for being here today. I'm Jim Harris with the Coalition for Common Sense, and along with Melissa Landry, Louisiana Lawsuit Abuse Watch, we welcome you and appreciate your attendance for this roundtable discussion, which will focus on the evolution of Louisiana's consumer protection laws. Before we get started, we'd like to also thank Lobby for hosting this event and for helping us with the accommodations. We very much appreciate that. As part of our mission to improve Louisiana's legal climate, CCS and L-Law partnered with the American Tort Reform Association to host this event. And we are honored that ATRA's President Tiger Joyce is with us today.
There's a lot that goes on in our society. I dealt with the Federal Trade Commission early in my, as Jim mentioned, when I was counsel to the Senate Commerce Committee. And I used to talk, when I had a chance to talk to the commissioners, even the chairwoman at the time and some of the senior officials, they talk about how hard it was, they got to find the right cases, they want to protect the consumers. And kind of like what Tammy was just talking about, I said, in those days, this is in the late 80s, early 1990s, just turn on cable TV, read, you hear these stories about these people selling, these ads for people selling things. I remember my mother telling me about somebody coming to her door trying to sell a water purifier. She said the thing looked like it was, it cost probably about 30 cents to make. They were selling it for $200. But protecting people, particularly elderly people, who can argue with that? That's in everybody's interest, and it needs to be done properly. The issue that we're focusing on is really a shift in the use of these consumer protection statutes, and candidly, in some cases, some abuses of these statutes when they are brought by private lawyers on behalf of private litigants. I think that dichotomy between consumer protection by regulators and law enforcement officials on the one hand versus private litigation is something that really merits attention. And we're so pleased to have this program today because Louisiana is a priority for us. We've had events like this. This is now the third state where we have had this discussion. Not necessarily, we've reached a conclusion, but we want to begin a dialogue here in your state leading to what we hope will be some meaningful and balanced and appropriate reform. So with that, I'm pleased to turn the podium back to Jim, who's, as I said, our great friend, and so pleased to be here with you and pleased to be working with the coalition and with Louisiana Lawsuit Abuse Watch as well. Thank you very much.
As everyone said, there seems to be a growing trend in the number of suits that are being filed on behalf of states seeking to address various violations of the consumer protection laws. What we believe those laws were originally created to be a shield for the consumer, and is now seem to be a sword for certain actors, and we wanted to discuss that. In order for us to get to that, we want to talk a little bit about the history of these laws, the current practices under those laws, and then look for some solutions and some consensus solutions as to where we should go. To that end, we've got three great panelists here.
Thank you, and thanks for the opportunity to be here and speak with you today. This is one of my primary areas of research, so I look forward to speaking with people who are more on the ground about these issues. So my role is to give you a little bit of history about consumer protection laws, both nationally and then more at the Louisiana level. I'll talk about how the Louisiana consumer protection law differs in significant ways from other states. And then I'll talk a little bit about the consequences of the expansion in the Louisiana consumer protection law and how it's having some harmful effects. So consumer protection litigation developed in the early 1900s to protect American consumers from fraudulent and deceptive business practices in commercial transactions. Initially, Congress, through the FTC Act to protect consumers, but soon after, many states followed with their own consumer protection laws. The states thought that knowing the details of their states more specifically, they could really tailor the laws to the specific needs of their states. These original laws sought to maintain a balance between protecting consumers on the one hand and preventing the proliferation of lawsuits that ultimately harm consumers and businesses on the other. So for example, these early laws, the majority of them restricted the enforcement power to the state's attorney general. In addition, there was only injunctive relief allowed under these laws. There were a few states that allowed private actions, but these statutes only allowed attorney's fees for knowing violations, and they required a showing of actual injury. So you could tell it's much more restricted than what we have today in a lot of states. In recent decades, many of the state consumer protection laws have devolved from their original intent. There's been surprising legislative and judicial overcorrections that are based on one very clear misguided idea, and that's that more consumer protection litigation necessarily benefits consumers. And what I'll argue today is that, in fact, the opposite could be true. As a result, many consumer protection acts in states around the country are starting to look more like consumer litigation acts. Louisiana has unfortunately been one of the worst offenders. Although the Louisiana Consumer Protection Law was enacted to protect consumers from unfair, deceptive commercial conduct, in recent years it has really devolved from its original intent and has been applied in ways that were clearly not anticipated by the legislature that originally enacted it. Although many of the consumer protection claims that are filed are necessary and important to protect consumers, there's plenty of examples of frivolous case and an overabundance of litigation which may actually be harming consumers instead of protecting them as was originally intended. So many indulgent provisions really set Louisiana apart and distinguish the law from the consumer protection laws in other states. I'll just go through a few examples. Number one, Louisiana is among a very small handful of states that actually mandates the trebling of damage awards in certain situations. So most states allow that, give that to the discretion of the judge, and the judge has discretion about when to double or treble damages. Most importantly, I think, for Louisiana is the standing issue. So Louisiana is very unique in that it does not restrict standing to harmed consumers. The majority of states do so. They restrict it to either consumers, or some states allow business competitors to also bring a claim. But the Louisiana law doesn't stop there. Essentially, anyone that can prove some ascertainable loss as a result of a business practice has a valid claim under the Louisiana protection law. So this is unnecessary for a lot of reasons, and for this you have to look back at kind of the purpose of these laws. Consumer protection laws evolved initially to protect consumers. That was the point. Some of the provisions that were added over time to these laws, such as attorney's fee awards, statutory damages, treble damages, had one purpose, and that purpose was to incentivize consumers who oftentimes may have suffered a small harm to bring the case in the first place. So if they're going to have to pay their lawyer and then receive a small damage award, they wouldn't bring that case. And so the thought was, well, award attorney's fees, and that way they'll have the incentive to do so. Obviously, those incentives don't exist when we're talking about a business-to-business case or even in a lot of employment litigation. But the Louisiana Consumer Protection Law actually extends to all of those situations. So not only do we have provisions that were not designed for the purpose of bringing business-to-business kinds of cases. In addition, there's a lot of other laws that we have enacted to regulate behavior in those business-to-business and employment interactions. So we have breach of contract law, we have business tort law, we have antitrust claims, we have employment protection. All of these laws are designed to protect those situations, and so we don't, in addition, need the ability to bring a Louisiana Consumer Protection Law claim. I'm avoiding using the acronym for what it is because I don't want to start speaking in letters. Instead, what we actually see is that these consumer protection claims are tacked on in a lot of cases because of the fear that they provoke. And the threat of receiving a treble damage award, the threat of mandatory attorney's fees is enough to often extract a quick settlement. And so we see these claims tacked on a lot, not only to legitimate cases where they should be brought, but also to less legitimate ones. In addition, so the third way that the Louisiana law varies from others is that it allows successful claimants supposedly to recover for ascertainable losses, but there's no clear definition about what constitutes an ascertainable loss. So in the law, we typically think about ascertainable being something that is monetary and quantifiable, out-of-pocket costs, actual kind of property harms or physical harms, but there hasn't been that sort of limitation in Louisiana in a clear way. Some judges have done that, others have not. So as a result, we have a lack of clarity about what kind of damages can be, claims can be brought for. We have a lack of clarity and really an expansion in who can bring those claims. And in addition, we have no real definition of what constitutes an unfair trade practice in the first place. So we have all of these areas of ambiguity that have really opened the doors for countless new categories of plaintiffs to at least make claims under the law. So, while initially celebrated as empowering consumers, the expansion of the original legislation may have tipped the balance from protecting consumers to encouraging excessive litigation. Louisiana ranks 8th in the nation in the number of per capita consumer protection laws that are brought. I'm working on another paper where we have more updated data, and the average growth rate of the consumer protection claims brought in Louisiana state's courts has been about 7.7% a year over the first, that was from 2000 to 2014. That's a very significant increase. In addition to trending upward, Louisiana's consumer protection litigation is significantly higher than other states in the region, largely because of these expansive provisions, indulgent provisions. So this increase in litigation inflicts costs on Louisiana consumers. Clearly, weak or frivolous cases will harm defendants, and there's plenty of examples with those. I have a couple in the paper which I can talk about, and some of them may not necessarily be frivolous in the claim being brought, but you can tell they are not the purpose of what a consumer protection law is meant to prevent. So, for example, there's a claim brought by a former employee against his employer for sending a cease and desist letter stating his intent to enforce a non-compete agreement that the employee willingly signed during his employment. So, we have employment protection laws to prevent these sorts of abuses if there was an abuse. Similarly, there's, I'm sure most of you know, the class action against major California winemakers and distributors claiming that the marketing of wine in Louisiana violates the consumer protection law because it doesn't warn that California wine may contain trace elements of inorganic arsenic. There's a claim brought by an aunt against her nephews for selling property in a real estate company without her consent. So again, maybe a valid claim, I don't know, but not really the point of consumer protection law. And then there's a claim brought by a defendant in a patent case against the plaintiff's attorney, because arguing that when the plaintiff's attorney put information about the case on his website, which most attorneys do, this was an unfair trade practice. So again, a lot of examples of how these consumer protection laws seem to be being made, the claims are made in cases that clearly were not intended. So when we have an overabundance of litigation, this can harm businesses, the consumers, and also the Louisiana economy. Both litigated and threatened consumer protection laws impose significant costs on businesses. Attorney's fees, regulatory costs, time costs can quickly add up. Although these costs are initially borne by businesses, they are ultimately passed on to consumers through higher prices, lower unemployment, and less innovation. So there's a body of empirical studies that show that increased litigation results in increased consumer prices. And similarly, there's empirical research that shows in states that allow excessive litigation against businesses, the economy is worse off. There's less employment, less production, lower GDP. In addition to harming businesses, consumers, and the economy, the litigation can burden the state's civil justice system. These cases generally slow state and federal dockets in other cases as well, increasing the delay and cost of litigation. So for example, when California enacted Prop 64, which was trying to rein in their consumer protection law, they immediately saw a 17% reduction in their consumer protection litigation, which benefited obviously the state budgets, the judicial system, and elsewhere. So fortunately, enacting a few reforms to the current law can help prevent abuse of the current legislation. If damages were limited to plaintiffs' actual out-of-pocket losses, like they are in many other states, this will eliminate the risk that entrepreneurial or overzealous juries will punish defendants with damages that are truly speculative and will in turn drive attorneys towards cases where the business practices actually produced a real monetary harm for consumers. In addition, restricting standing to harmed consumers will ensure that the Louisiana Consumer Protection Law actually protects the consumers it was designed to protect. The protection beyond harmed consumers is unnecessary and redundant given the proliferation of laws governing non-consumer business interactions, and instead is used to induce threats and quick settlements. So to sum up, indulgent provisions and judicial interpretations have led to significant increases in Louisiana's consumer protection litigation over the past couple of decades. Under the current law, much of the litigation is challenging behaviors that were not originally intended as the target of the consumer protection law, such as business practices that affect employees or other related businesses. Similarly, they are protecting business practices that don't actually result in any sort of quantifiable monetary harm. If this litigation continues, the consumer protection law has the very real potential to harm consumers instead of helping them as was originally intended. Thank you.
The professor's covered much of what we've talked about here, but I just want to give you, again, our view from the defense bar side. So anyway, the goals of LUPTA, according to the recent Supreme Court's pronouncement, is halting unfair business practices, sanctioning the businesses which commit them, preserving and promoting effective, fair competition, and curbing business practices that lead to a monopoly and unfair restraint of trade. And this is the pronouncement as of May of 2014 by Louisiana Supreme Court. And as you can see, it's extremely limited as far as what it's attempting to accomplish according to our Supreme Court. And in fact, the jurisprudence over the years, if I can get to the next slide here, let's see. This is what, and I believe it to be a heavy burden. The plaintiff must show the alleged conduct offends established public policy and is immoral, unethical, oppressive, unscrupulous, or substantially injurious. If you look at that standard, and again, that's in the Sheremy case in 2010, the case which expanded standing. But this is the plaintiff's burden, which seems quite substantial, especially if you're a business and being sued, or again, if you look at what the Supreme Court has said with regards to its true parameters, and then you combine this with what the plaintiff must show, it seems it's going to cover a very limited set of circumstances and quite egregious behavior, as it says, unscrupulous, unethical, oppressive behavior. And so there's a narrow, I believe to be a narrow application. The range of prohibited practices under LUTPA is extremely narrow. This is, again, our Louisiana Supreme Court that has said this, as LUTPA prohibits only fraud, misrepresentation, and similar conduct, and not mere negligence. Again, this is a quote directly from Sheremy. Taking it one step further, the conduct it offends established public policy and is unethical is not necessarily a violation of LUTPA. Again, this is Louisiana Supreme Court. It says only egregious actions involving elements of fraud, misrepresentation, deception, or other unethical conduct will be sanctioned based on the Louisiana Unfair Trade Practices Act. So you have this context in which Sheremy, our Louisiana Supreme Court, has said it should have a narrow construction if you were to look at that. So then you ask, why are we here? And Professor Shepard has touched upon that. Because of the way it's being construed by our courts, as well as the broad language that's in the statute, and very talented lawyers like Mr. Bartlett are expanding that. One is the standing issue. Under Sheremy, as you know, it's any person can bring this particular claim, any person. And that was certainly not the intent, as we've talked about, as the professor raised, regarding the FTC Act and what was originally thought to be the true purpose of it. The operative language is broad and has been construed broadly, even though you saw where Sheremy, a recent pronouncement in 2010, has attempted, in quoting, I think correctly, its limitations. And finally, it's the attractiveness of attorney's fees and treble damages. One of the things that Professor Shepard had mentioned in her comments is that it was to incentivize the consumer to otherwise bring a claim that needed to be brought to the attention of the courts or otherwise to satisfy that wrong or remedy the wrong that happened to that consumer. But instead, because Louisiana does not allow attorney's fees except in very limited circumstances, including not on a breach of contract, unlike Texas and other states where you could have a breach of contract, you can actually recover attorney's fees. You cannot in Louisiana. And so this becomes something that's on every breach of contract claim now or any other type of claim. So the plaintiff can recover attorney's fees. And there is the threat of treble damages, although it's been rarely awarded here in Louisiana. But it is a possibility. So, and again, I just quoted here just the statute regarding any natural or juridical person who suffers any ascertainable loss of money or movable property, corporeal or incorporeal, as a result of the use or employment by another person of an unfair or deceptive method, act, or practice declared unlawful by Section 1405. And as you can see, that language is much broader than what I presented to you earlier on Sheremy. And as a consequence, courts are frankly confused by the brilliant writings of the plaintiff's bar and otherwise have expanded this unnecessarily. If they go back to the original roots, if they go back even to our jurisprudence, there's sufficient grounds to limit the application of the Unfair Trade Practice Act and apply it in its intended purpose and to protect consumers. So, talking about some of the defenses and limiting the scope, obviously there's a potential to have legislative corrections, but note there's exemptions in like 1406. For media advertisers, there's an exemption for false ads when falsity is unknown and no financial interest. And entities that are subject to state regulatory bodies, utilities, banks, lawyers, brokers, insurance, are carved out in Louisiana. So are there other potential carve-outs? It's one of the questions. Or should there be additions to those carve-outs? Because I will tell you, having done defense or foreclosure work for banks, I will tell you that almost universally, if you're foreclosing, that the individual, the debtor, will bring an unfair trade practice claim. You'll have it dismissed, but again, they will bring it saying this is a lender liability claim, and in fact, you've been oppressive, unscrupulous, and as a consequence, I'm going to attempt to recover my attorney's fee. So it is appended to everything, even when they don't have standing against, say, a bank, or a lawyer, or a securities broker. So one of the thoughts is, should we expand those carve-outs? Now, the Fifth Circuit has observed that the real thrust of the Louisiana Unfair Trade Practice Act, it's modeled after the FTC Commission Act, and it is to deter injury to competition. So, should the courts extend that injury to competition qualifier? If there is not an injury to competition, should you be allowed to bring an Unfair Trade Practice Act? So, this is something that came out of the Omnitech case in 1994. It was actually, it's been tested and at times has failed, frankly. But it's something that should be thought about from the defense perspective and for businesses if they're sued, that it really was designed to deter injury to competition. And so another potential qualifier in limiting the scope of its application. Again, defendant's actions must have been taken with a specific purpose of harming competition, an intent and/or bad faith required element. This is a Second Circuit case that came out in 1998. And so was there an intent to harm competition, or was there true intentional conduct and bad faith? If there is, for the wrongs that it's intended to cover, again, if the plaintiff has to prove intent or true bad faith, it's going to limit its applicability. And so one of the things that the Second Circuit has actually adopted this too has been tested and rejected by certain courts. But nonetheless, it is there as a defense and perhaps should be something that can be incorporated either statutorily or should be raised by defenses in defending against these type of unfair trade practice claims. There's also this doctrine called otherwise actionable. For example, tortious interference with contractual relations is not recognized in Louisiana except in highly limited circumstances. There was a case that came out of the Middle District of Louisiana, the Shaw case in the early 90s, where they brought a tortious interference claim, which was not recognized in Louisiana, and they said the court found that you can bring a unfair trade practice act based on tortious interference, even though that particular cause of action was not recognized in Louisiana at that time. It's saying here it falls in the category of unfair trade practice. So again, expanding our standard or attempting to limit its scope, otherwise actionable. You can't make up a tort. It has to be something that otherwise would be actionable, but there should be no other remedy, right? It shouldn't be an add-along. As Professor Shepard talked about and pointed out very correctly, if there is a labor law that would otherwise protect that particular situation, or if there is your standard tort law that would protect that situation, why is it that you would otherwise have the ability to append a unfair trade practice act? But certainly it shouldn't be used to invent some type of business tort. And so this is something that was decided in American Waste by the Fifth Circuit in 1991. One question I have, and I pose, again, some more thoughts, can you contract out of the liability? So businesses, should you write in that you cannot be sued for an unfair trade practice act? Should you be able to contract out that you won't be able to recover attorney's fees or treble damages? Nope, we have a public policy in Louisiana that prohibits contracting out of fraud, intentional fault, or future tortious conduct. And so the question is the Unfair Trade Practice Act, does it fall closer towards the fraud, intentional fault, and future tortious conduct? Or is it, because it's so amorphous and the way our courts have applied it is so broad, you should be able to contract out of it unless it's truly that intentional bad conduct, right? Because our courts, when we began this conversation, I showed you Sheremy and how it was very limited. It seems if Sheremy defined the limitations, you may not be able to contract out of it because it really was this egregious, horrible behavior, right? It needed to be corrected. And Louisiana won't let you contract out of that type of activity. But because it's grown and it's become so expansive, I would argue that you in fact can put this in a contract and should be able to contract out of this type of liability. I think that was it for my slides, and so that's it for my presentation. But thank you very much.
I would like to present what I'm calling a picture of the balanced use and evolution of the Unfair Trade Practices Act. And my original draft of my presentation, the parentheses here had a plaintiff's practitioner's perspective, but as I thought about it, this is really more just a practitioner's perspective. Professor Shepard has given us a very detailed policy examination, and I think Mark and I can talk about, just from a practitioner's perspective, on the ground, how do the various balances within the Unfair Trade Practices Act play out. And the reason why I want to emphasize this is purely a practitioner's perspective is because my clients who bring these claims often are you. My clients are businesses and business people who've been very successful and have gotten involved in business disputes where there has often been something more than just a standard breach of contract or breach of fiduciary duty. There's something more. There's that egregious conduct that the Sheremy Court talked about, and that Mark discussed, and that you'll see again that language in my presentation. And it is for that protection of businesses from egregious misconduct, from intentional, just really terrible, over-the-top conduct, that we believe that the balanced application of the Unfair Trade Practices Act is something that is beneficial to businesses in Louisiana. So with that in mind, I'd like to go through just sort of the basics of what we're talking about. What's the language in the statute that we're looking at? Now, the liability language, the scope of liability in the statute is admittedly fairly amorphous. But as we'll see, as that language has evolved through its application by the courts, has become pretty specific to a very narrow range of conduct. The statutory language is that unfair methods of competition and unfair or deceptive acts or practices in the conduct of any trade or commerce are hereby declared unlawful. Now, who can bring these claims privately? There are plenty of provisions in the statute that talk about the Attorney General's ability to enforce against deceptive trade practices, and I don't think that's what we're talking about today. Right now, we're talking about the private right of action, my clients, you, what you can bring. Who the statute says can bring a private claim. Any person who suffers any ascertainable loss of money or movable property, corporeal or incorporeal. So not quite so far-ranging, I don't think, as we've been discussing today. As a result of the use or employment by another person of an unfair or deceptive method, act, or practice declared unlawful by the statute, may bring an action individually but not in a representative capacity. Now, this is key to understand that perhaps unlike some other states, the Louisiana statute does not allow class actions based on LUTPA. The wine case purports to bring a class claim under LUTPA. That's not my case. I would not have had that in any of my complaints because the statute clearly doesn't allow that, to recover actual damages. And that's another key restriction and another key balance, I think, in Louisiana's version of the Unfair Trade Practices Act, is you can't just go out and seek a very speculative level of damages. You have to be able to prove actual damages, which I think is a good balance in the statute. Obviously, one of the things that we're discussing today from a policy perspective is the availability of attorney's fees in the statute. Again, this is a place where I think the statutory language is going to show you there is actually a balanced approach already in the statute, that the policy decisions made by the legislature when they enacted the Unfair Trade Practices Act were a balanced set of policy decisions. The provision that we've already discussed today is the provision for reasonable fees for the prevailing plaintiff. In the event that damages are awarded under this section, the court shall award to the person bringing such action reasonable attorney's fees and costs. However, in the same section of the statute, there's a balance against that. One of the things that Professor Shepard talks about as a legitimate policy concern is when you have amorphous statutory language that could encourage the bringing of frivolous claims. However, there is a protection in the statute to disincentivize the bringing of such claims. Upon a finding by the court that an action under this section was groundless and brought in bad faith and for purposes of harassment, the court may award to the defendant reasonable attorney's fees and costs. So this is a restraint, frankly, on me from suggesting just to any client who might be able to somehow say there's something unfair about the way I was treated, of just sticking that LUTPA claim in any complaint or petition that I draft, because I know that my client then is going to be subject to this counterbalancing attorney's fee provision, that there needs to be really some meat to those claims, and that it needs to fall within the egregiousness standard that we're going to talk about in a couple slides. And one of the things to understand is that under Louisiana law, attorney's fees have been found by court after court, and by the Louisiana Supreme Court specifically, not to be a policy decision made by legislatures to incentivize the bringing of claims, or even necessarily to make a plaintiff whole. What attorney's fees provisions under Louisiana law are there for are specifically to deter the conduct that's being prescribed by the statute. And here it's to deter taking particularly egregious actions within the business or trade context. So to the extent we talk about policy solutions for these attorney's fee provisions as being out of whack with some incentivization policy to incentivize plaintiffs to bring claims, that's actually not why the attorney's fees provisions exist under Louisiana law. And then the other thing to understand about attorney's fees is that this provision for reasonable fees under Louisiana law is not an amorphous standard. It's actually a very strictly prescribed standard. There's a 10-factor analysis for reasonableness that's applied to any attorney's fee provision by Louisiana courts that derives specifically from the rules of professional conduct that govern lawyer behavior. And it looks at the ultimate result obtained, the responsibility incurred, the importance of the litigation, the amount of money involved, the extent and character of the work performed, the legal knowledge, attainment, and skill of the attorneys, the number of appearances involved, the intricacies of the facts involved, the diligence and skill of counsel, and the court's own knowledge. Now, these factors are the factors that any Louisiana court is going to look at to determine if a fee is reasonable. They're not going to look just, for instance, at my attorney's fee contract, say I've got a case on a contingency basis and go, oh, well, look, you've got a 30% contingency, we're just going to award you that. That contract language pretty much goes out the window. Instead, the court applies these 10 factors to make sure that whatever the fee is reasonable under the particular circumstances of a case. So I think it's important to understand that when we're talking about policy reasons to adjust the attorney's fee provisions is what are the restraints already in place, put in place by the Louisiana courts. Of course, another aspect of the Unfair Trade Practices Act that we're discussing from a policy perspective today is the treble damages provision. And there it's important to realize that the statute already has a very narrow prescription on when treble damages applies. First, it's only going to be for a knowing violation of the prohibition under the Unfair Trade Practices Act, and only in cases where the violation has continued after notice has been provided by the Attorney General. The language in the statute is if the court finds the unfair or deceptive method, act, or practice was knowingly used, and under Louisiana law, that knowingly means used intentionally or maliciously. After being put on notice by the Attorney General, then the court shall award 3 times the actual damages sustained. We almost never seek treble damages, and our Louisiana Unfair Trade Practices Act claims that arise from egregious conduct in a business-to-business situation, because there you're typically not dealing with an ongoing deceptive act. That's more geared towards the traditional consumer claims that Professor Shepard was discussing was the original genesis of these types of statutes. So one question I'll have, and I think that we'll discuss as we go along today, is to what extent the treble damages language in the Unfair Trade Practices Act actually requires any kind of policy adjustment because it's already so narrowly prescribed. So the big change, I think, in Louisiana law, or at least the one that everybody talks about as being a big change, is this Louisiana Supreme Court decision from 5 years ago, Cherami Services versus Shell Deepwater Production. Prior to Cherami, most of the Louisiana intermediate appellate courts, with the exception of the First Circuit, the Second through Fifth state circuits held that only consumers or competitors had standing to bring claims under the Unfair Trade Practices Act. And that's despite the language in the statute itself not having that limiting language. So what changed with Cherami is Justice Weimer wrote regarding standing, looking just at the language in the statute, LUTPA, pardon me, I'm a former environmental attorney, so I do speak in alphabetical gobbledygook, and it's hard to get me to stop. LUTPA grants a right of action to any person, natural or juridical, who suffers an ascertainable loss as a result of another person's use of unfair methods of competition and unfair or deceptive acts or practices in the conduct of any trade or commerce. Although business, consumers, and competitors are included in the group afforded this private right of action, they are not its exclusive members. Any such limitation that has found its way into the jurisprudence resulted without proper analysis of the statute. Now, Justice Weimer's opinion also did some other things with regards to LUTPA, and we've seen this in a lot of the cases that we've had. I've had some cases with Mr. Beebe where I see this language time and time again in their briefs. Whoops, let me go back. Is it ratcheted down on the scope of liability under LUTPA? While the standing part of his opinion gets most of the attention, he addressed liability and recognized the very limited scope of liability, that the courts have repeatedly held that the plaintiff must show the alleged conduct offends established public policy and is immoral, unethical, oppressive, unscrupulous, or substantially injurious. Now, This is very kind of limiting sounding language, but just that by itself could still perhaps be seen as amorphous. But then he goes on to say that the range of prohibited practices under LUTPA is extremely narrow. We're not talking about any business-to-business dispute. And then something that he did that the Louisiana Supreme Court had not done before Cherami is he incorporated very restrictive language on LUTPA that was articulated by the U.S. Fifth Circuit and Turner versus Purina Mills, a case in 1993, where he really, this really kind of puts the meat on the bones of this otherwise amorphous language, that LUTPA does not prohibit sound business practices, the exercise of permissible business judgment, or appropriate free enterprise transactions. The statute does not forbid a business to do what everyone knows a business must do, to make money. Businesses in Louisiana are still free to pursue profit, even at the expense of competitors, so long as the means used are not egregious. Finally, the statute does not provide an alternative remedy for simple breaches of contract. There is a great deal of daylight between a breach of contract claim and the egregious behavior of that the statute prescribes. And later on, he goes on to write in the opinion, only egregious actions involving elements of fraud, misrepresentation, deception, or other unethical conduct will be sanctioned based on LUTPA. So what happened in Cherami is you had this sort of collection of very limiting language from different courts coming up through the federal courts, some coming up through the lower state courts, that then all coalesced in Justice Weimer's opinion in Cherami to provide a very uniform view of a very limited statute that is aimed solely at claims that go beyond the simple antitrust claim or the simple breach of contract claim or breach of fiduciary duty claim to something that involves a level of egregiousness above and beyond that therefore required this deterrent effect of the additional remedies of attorney's fees. And I would say the treble damages provision there, that's not the kind of claims we're talking about. Those are more consumer protection type claims. And the surprising thing is that we haven't talked about today is that Cherami actually did not settle the standing issue. The policy concern that's been articulated today that Cherami has opened up LUTPA to all these claims by anyone actually isn't true. And this is something we've run up against. And frankly, in my cases for my clients, I tell them if you're not a consumer or competitor and we can't make that argument, we need to think long and hard about actually bringing a LUTPA claim regardless of how egregious the behavior was. And the reason is, under Louisiana law, under our conception of authoritative value of opinions, if you don't have a majority opinion out of the state Supreme Court, if it's just a plurality decision where you don't have a majority of the justices ruling on a particular issue, on that issue, the only authoritative effect for that determination is for that case. It actually doesn't have authoritative effect on other cases. And on standing, on that issue, only 2 other justices joined Justice Weimer. So that was a 3-3 decision on the issue of standing. 3 of the other justices argued that, well, because you're dismissing the case anyway, what you've said on standing is just dicta. And one of the justices said, Justice Johnston said, I don't agree with you about standing, that LUTPA should only apply to consumers and competitors. So on that, Cherami is not authoritative. However, it was 6-0 on the other parts of the opinion that I've been talking about, ratcheting down on the scope of liability of LUTPA. So to the extent that we're looking for policy solutions to what may have been amorphous language, the courts have already gotten there. The courts have already understood the balance that's been achieved in protecting businesses involved in these sorts of egregious relationships. And because of that split in Cherami, subsequent decisions are really hesitant to actually apply Cherami as an end-all, be-all on the issue of standing. Just sort of some final thoughts that really aren't final, but more perhaps introductory to the discussion we're going to have. If you've had a chance, or when you have a chance to look at Professor Shepard's white paper, there's a lot of the facts come from this Searle report out of Northwestern University. I tried to reproduce those same results. It talked about the number of cases and reported decisions that involve LUTPA. It said that there had been 569 in federal and state cases in Louisiana from 2000 to 2009. I ran a search described exactly as it was in the Searle report and came up with 191. There have been 282 more such decisions since 2010. But I think more to the point of our discussion, does having LUTPA as part of my arsenal, right, as part of the tools that I use, does that increase the number of lawsuits in courts? I would argue that it doesn't. I've never seen, first of all, a claim that is solely a LUTPA claim, a claim that is not a lawsuit that's been brought that doesn't have other claims with it. Indeed, all the cases cited in the white paper involve multiple claims aside from LUTPA. One had 8 different causes of action, another had 6, another one had 2. These are lawsuits that would have been brought regardless, but there's been a LUTPA claim appended to them. Now, the wine case, it shouldn't have been in there, at least as a class action. I will tell you, none of those cases are mine, and I see problems with quite a few of them based on the language in the statute. And even the Searle report, which Professor Shepard cites, concedes that the majority of reported Consumer Protection Act decisions in the sample that they looked at included between 2 and 6 total plaintiffs' claims. So if the policy analysis is looking at how to reduce the caseload in the courts, I'm not sure this gets you there, because these are lawsuits that are getting brought anyway because there has been conduct violative of contract terms. So you have breach of contract claims, or you have antitrust claims under the state antitrust laws or federal antitrust laws, or you have breach of fiduciary duty obligations. So just a question about how effective getting rid of the LUTPA remedy is to reducing the caseload in the courts. We have plenty more to say in response to the question. So thanks again for having me. I'm looking forward to the discussion.
My message is that consumer protection laws have devolved greatly from their original intent. Originally, the purpose of both federal and state consumer protection laws was to protect consumers from unfair business practices, but there were very strict limits on the abuse of these laws. So most early laws, for example, only allowed enforcement by state's attorney general. They only allowed damages for actual injury. They did not automatically award attorney's fees unless there were knowing violations. There were several restrictions because people were concerned that they could potentially be abused. And unfortunately, over the last couple of decades, a lot of states, Louisiana included, have expanded these laws beyond that original purpose. And so they often include redundant provisions that not only protect consumers from business practices that should be prevented, but they also have encouraged excessive litigation. They've encouraged entrepreneurial lawyers to find claims where they may not otherwise have been, and it's really because these laws have changed substantially from their original purpose.
Ultimately, because of the broad interpretation and application of this law, which seems to have departed from its original intent, it results in expenses to companies in not only defending these lawsuits, but also having to pass on these expenses, these costs, to the consumer. So not only is it an expense to the businesses, but it's also ultimately results in additional expenses to the consumers. And the law was, of course, designed to protect those consumers. So
businesses that are affected by this, how does it affect their ability to create and retain jobs?
Well, obviously they're greatly undermined in their ability if they're having expenses that are dedicated to fighting what we consider to be frivolous lawsuits, or lawsuits that are overly aggressive. And this is not a stopgap measure, although many plaintiffs' firms and lawyers are using it in order to recover attorney's fees or otherwise bolster damages they wouldn't be able to recover under Louisiana's general tort law or general business tort law.
Typically, my clients are business people. They're either entrepreneurs who've been very successful and have gotten into business relationships with other businesses, and that relationship has gone sour. And when the Trade Practices Act becomes involved, it's more than just a relationship going sour. It's where there's been some very egregious or intentional conduct that's been involved, which is one of the things I'll talk about, that the statute is very specifically aimed and targeted, and we think a very balanced statute. So it doesn't often come into our business dispute cases, but when we have those cases where there's been egregious conduct, then it is something that we consider.
Tell us what changes, if any, would you like to see in Louisiana's consumer protection law?
I think just a greater clarification from the courts on how the liability standards will be applied and how the standing standards will be applied. And I think that's probably something that I share in common with Mr. Beebe and Professor Shepard. So,
from our standpoint, these laws need to be brought back into conformity with what they were intended to do, which is to protect consumers. And we think in most instances that's best done when individuals who are empowered by the state regulators, people enforcing laws for the state exercise appropriate discretion, that they don't become an unregulated tool for personal injury lawyers to win large verdicts and enormous fees.
If people have questions like more information, what should they do?
You come to our website, www.atra.org. Simply contact us, the American Tort Reform Association in Washington, D.C. We'd be happy to provide more information. It's a lot on our website, and we're happy to help and support anybody willing to help us in this regard.